Limchaco. So, Senator, you still have the floor.
Thank you, Madam Speaker. During the recess, we were able to determine that where we left off last, certain amendments should be made to Section B, or excuse me, B of Section 2, Item B. And I'd like to request for the following amendment to be made. And I discussed this with the author, and we agreed that some of this information is covered in Section 2A. So starting on line 1 on page 3, the following sentence should be removed. Every deposit beverage distributor shall pay to the department a deposit beverage container fee on each deposit beverage container manufactured in or imported to Guam. That should be completely striked out.
So delete on page 3, lines 1 and 2, and for 3 to Guam, that whole sentence. On that amendment, no objections?
Can you explain why? It's covered in Section 2A.
It's covered in where?
It's redundant, Madam Speaker. It's covered in Section 2A already. Same language.
Okay. All right. So on the amendment, no objections. So ordered.
Thank you, Madam Speaker. The sentence that should remain: the deposit beverage container fee shall not apply to deposit beverage containers exported for sale outside of Guam. That sentence shall remain in Section 2B. And then the remaining sentences shall be also removed. The fee shall be imposed only once on the same, the following sentence: the fee shall be imposed only once on the same deposit beverage container shall remain in as well.
Okay.
And then the following sentence: the fee shall begin at 1 cent per deposit beverage all the way to where the sentence ends. Chapter 44 shall be stricken from the section as well.
Okay, so everybody understand that the last sentence, starting from lines 5 to 7, where the fee shall begin and end at chapter 44.
And the reason why we're taking that out, Madam Speaker, is that is covered in Section C and refers to the startup costs associated for the bottle bill, where initially there was going to be this imposition of 1 cent per container in order to establish that startup fee. So the author recognizes that it was her intent that it should be covered in Section C, and therefore that section should be removed from.
So Section C, which starts on line 8, we're looking at. Oh, you're gonna make okay, all right. So
yeah,
we just want to make sure then that what. Okay, so on that amendment then to delete, Senator Ada, you're recognized. To delete lines. Oh, that last sentence.
Well, I guess I have a problem with that line 3 and 4. I guess with the amendment of deleting lines 1 and 2.
Can you please discuss that on the mic, Senator?
I'm sorry, Madam Speaker, I support the amendment to delete line 1 and 2 and to delete lines 5, 6, and 7, starting with the word "the fee shall begin." But I guess we should dispose of that. But I do have reservations with line 3 about the deposit beverage container fee shall not apply to containers exported for sale outside of Guam.
Okay, so let's go ahead and delete then and deal with the deletion of the last sentence on the sub B. So any objections to that? There be none? So ordered. Now then for just looking now, since that whole sub B section has been now amended, then Senator Ada, you're recognized then to discuss that.
So Madam Speaker, I have concerns about then what's left there about that the the fee shall not apply to beverage containers exported for sale outside of Guam. And here's the reason why. If we take a look at page 6, we see that a requirement for each container that is brought in must have the marking Guam or GU. So regardless of whether, you know, this distributor is going to bring this product in and transship it off to one of the islands out, that can could eventually work its way back here and would be eligible for redemption because it has the, I mean, unless the distributor is going to order, let's say, 100 cases of beverages, right? And that maybe 80 cases of that beverage is for sale and consumption on Guam, and the other 20 cases is for distribution throughout the region. I would imagine there's going to be those additional costs incurred to then say, just this much will have the markings GU, and, you know, I imagine that distributor is going to say, just mark everything GU. And so, you know, an enterprising individual out in the region could say, let's just collect these things, and at the end of the year, we'll pack it all up and take it to Guam and redeem it. But then there's no money, there's no fees that was assessed for those containers because it was exempted because it was being transshipped. This is very much unlike, you know, we transship fuel to the region through Guam. And for those, we exempt those that commodity from the fuel tax on the premise that, well, it's not going to be consumed here on island and it's not going to cause the pollution here on island, and so therefore we should not subject it to the liquid fuel tax because it's going to get consumed out in the region. Well, that's fine. We know that that fuel is not going to find its way back to Guam. But that's not the case for these beverage containers. And so I actually would like to make an amendment that would read that the beverage container fee shall apply to beverage containers exported for sale outside of Guam, because unless somebody can say with absolute certainty that those containers are not going to make its way back to Guam because it does have value and it has all the markings that will make it eligible for refund, we're going to get ourselves caught short. So, you know, we can leave it like that. But then if we're going to then exempt those beverages from the deposit, the fee, then we probably need to go to page 6, that section 44.115, and remove that requirement to have that can marked GU. And I think when we get to that section, we're going to need to really look at that requirement closely, because if the military is going to get in on this program, if it ever does, you know, it orders its beverages on a worldwide contract. So it orders it by the millions of cases, and it's not, you know, give me the 100 cases, mark it 100, or mark it GU for Guam. I don't think they're ever going to get to that. So, so because of that, I have serious concerns about exempting those beverage containers from the fee. And I would like to make the amendment that then on line 3, we strike the word not, such that then it will read, the deposit beverage container fee shall apply to deposit beverage containers exported for sale outside of Guam.
On the amendment then, on page 3, line 3, to delete the word not. On the amendment, Senator Lim Tiaco, you recognize.
Madam Speaker, although the bill 108, I'm not an author for it, I need to just raise an objection to the amendment, and I'll just say this: for the purposes of the businesses that are involved in this type of business, I guess what we're asking them to do is pay a fee to help accomplish the recycling of this. And Senator Ada, for many points, is correct in the sense that we don't know if these bottles will make its way back to Guam and therefore be redeemed for whatever amount that the bill requires. We're still asking the businesses to pay this deposit fee based on the intent of accomplishing what this bill attempts to accomplish. I think that's unfair to those businesses to charge them 5 cents or whatever the deposit fee would be per container when we cannot assure them that we're going to handle all of the, in the case that those containers do come back. How could we justify charging these businesses for a fee that would not otherwise go to accomplish what this bill attempts to accomplish? So we're basically putting a surcharge on these on the same thing. And if we follow that same logic, do we have to change our export laws so everything that is exported off of Guam should be subject to 4% GRT, because it's somewhat the same thing. It's somewhat the same instances where they're exporting the goods off island, and when you think of it in that sense, the logic would dictate that you would have to remove that law and just charging everybody 4% for exporting their product. So I'm trying to understand, and I understand what Senator Ada is saying, is that in the eventuality that some extremely entrepreneurial person somehow loads up a plane load of empty bottles for 5 cents and brings them back to Guam to redeem them, one, I don't think it makes financial sense to do that, and the eventuality is probably, not a very real probability, but it doesn't make sense to charge the businesses that are engaged in this business for product that does not otherwise get consumed on the island. So I object to the amendment.
Thank you, Senator. On the amendment, Speaker Pangilinan, you recognize.
Thank you very much, Madam Speaker. Madam Speaker, I rise to echo basically the same concern of the retiring speaker. I understand what could occur, but the likelihood of that occurring, I think, is given the cost of shipping it back. The reason why these redemption centers are able to do this is they bring, with the exception of plastic these days, really, but on the aluminum cans, because when they package it up and they ship it off island, they resell that product, so there's a value to that over and beyond what the redemption value would be of 5 cents per can. If you took a look at, for example, in the can, and if you're only going to get 5 cents per can, how many pounds would that be, and what would be the shipping cost of that to come back to Guam? And I'm not sure really that it would be even economical to just ship it back to Guam purely for the 5 cent redemption value and no additional value for the material itself. And that's why recycling programs are usually have to be subsidized in some form or fashion, because even at times when you sell the product itself or the material itself, it still doesn't cover your redemption costs, and it doesn't cover the shipping costs. And some of these are able to do so because of other operations that they have and tie into that, which helps that. And of course, some of them are because of their concern for the community. So it would add a cost that is not really attributable to bringing it into Guam and for the recycling. So I'm just not sure if that would be appropriate at this time to impose a cost on the consumer as well as the distributor when the service to provide that would be for assessing that cost, which is the redemption of that from our environment, may not ever be realized. So that's the only concern I have. It would help us definitely, because we would then have less of more money and less redemptions, because we know that not 100% get redeemed. So that if some entrepreneur decides to collect the cans from the rest of Micronesia and the CNMI to ship them to Guam, you're still not going to get 100% redemption, but you get 100% assessment upon importation. So it would be good for a recycling program, but is it fair is the basis that I'm looking at it. Thank you.
You're welcome. Senator Mike Nicholas on the amendment.
Thank you, Madam Speaker. On the amendment, I wanted to, I guess, get some clarification. To my understanding, this bill is going to assess a fee on the containers. So if we're bringing those containers back in, let's say they're transshipped through Guam to a neighboring island, and then somebody gathers all those containers and imports them back into Guam, shouldn't those containers then, at the time of importation, be assessed a 5-cent fee?
And who would you like to address
I
the
guess I would
question
pose
to?
that to the individual presenting the amendment, Senator Atta.
Senator Atta, do you yield to the question?
Okay.
Okay. So you may proceed,
Okay.
and maybe we'll think in our minds exactly
Sure.
how-
Okay. Well, and the reason why I'm asking the question, Madam Speaker, is if the fee, the 5-cent fee, is being assessed on the importation of the container, then even the used containers coming back in would theoretically be assessed the same fee. And if they are assessed the same fee, then it would be a net zero incentive for anybody to try and bring containers back into Guam to recycle them, because they would have to pay the fee to bring the container in, only to redeem the very same fee on that same container. So I don't think that the amendment would be necessary to protect us from somebody gathering up a bunch of recyclables outside of Guam and bringing them back in to redeem, because upon bringing those containers back in, whether they're used or unused, bringing the container itself back in, because it's specified based on the material of the container, I would assume bringing the container in would be a would result in the fee needing to be assessed, and so there would be no incentive to bring those containers in to collect on the fee. So I wanted to pose a question because I'm not quite sure if I'm interpreting that correctly, but if I am, then I don't think that the amendment would be necessary to protect us against an unforeseen expense item on the reimportation of those recyclables. Thank you, Madam Speaker.
Can I,
Madam Speaker, so that we can move on to more substantive points of the bill, I would withdraw my amendment.
on the withdrawal, no objections, so ordered. Senator Lim Tiaco, you may continue.
Thank you, Madam Speaker. Madam Speaker, I'm sorry that I might be going a little backwards here, but if we can just go back to page 2 in regards to the definition section of the bill under section 1Y, refund value. And if we can, maybe just a point of inquiry. If I understand this correctly, the refund value as defined refers to the amount of the deposit required for distribution and sale of beverage containers in Guam that shall be paid to the redeemer in exchange for an empty deposit beverage container. And, then the following section BB, redemption rate, further defines how a redemption rate is calculated. However, it's unclear whether or not the refund value is based on the redemption rate. And if the author would yield to a question as just a point of clarification, point of inquiry as to whether or not the refund value is the same as the redemption rate.
Senator Muñoz Barnes, do you yield to the question? Again, Senator, do you want to please repeat the question?
Yes, is the refund value and the redemption rate one and the same? Or is the refund value based on the redemption rate? Because in the definition of the refund value, it says, refers to the amount of the deposit required for distribution and sale of beverage containers in Guam that shall be paid to the redeemer in exchange for an empty deposit beverage container. And then the redemption rate basically goes on to also talk about the how you calculate this redemption rate. And I guess the reason why I'm asking this definition section, Madam Speaker, is because in the proceeding section 2C, there's a question as to how to apply those definitions.
Okay, can we, I think senators, senators, please, we can't just be having conversations between ourselves, amongst ourselves. So if you want to have this discussion, I will give you a recess, and then later on, maybe you'll be able to discuss this on the floor. Okay,
Thank
so
you,
we'll
Madam
take a brief
Speaker.
recess. Senator Munya Barnes?
Yes, Speaker, but based, in the interest of time, and based on some of the concerns regarding the definitions of, as proffered, I'd like to go ahead and move and set this bill aside, and if we can come up with the answers to the increases afforded, then we'll go ahead and bring it back. So if we can just move to set it aside, and then be able to entertain the questions, and then if everything's satisfied, we'll come back if that's okay.
Yes, thank you very much, Senators, on that motion. Without any objections, so ordered. Bill 107, Senator Macready, you recognize.
Thank you, Madam Speaker. I would like to make a motion that Bill 10732, as substituted by the Committee on Guam U.S. Military Relocation and Veterans Affairs, Homeland Security, and Judiciary, be moved to the third reading file. I'd like to discuss.
You may proceed, Senator.
Thank you, Madam Speaker. I would first like to take this opportunity to thank some co-sponsors. I'd like to thank Senator Dennis Rodriguez, Senator Mike Nicholas, Senator Tina Rose Munya Barnes, Senator Tony Atta, and Senator Mike Limtiaco. I would like to also add on Senator Tommy Morrison and Senator Rory Respicio as co-sponsors.
So first of all, the motion is that you want to place it on the third reading.
And
Okay,
discuss.
and you want to speak on it?
Speak on it, yes.
Okay, then you may proceed, and
Thank
then
you.
now, of course, your first amendment.
My first
that you
amendment
want
would be,
to,
I would like to proffer an
will be
amendment to add
Senator
to
Morrison.
add Senator Respicio and Senator Morrison as co-sponsors.
Okay, Respicio first, then Morrison.
Yes.
So then, you're right, so then, yes, with, I mean, you've made the motion, you're right, and I've accepted it, and you are, of course,
Now I wanna
going to briefly discuss it,
talk-
but,
discu-
but before you even do discuss it, now you're making this first amendment, then to add Respicio and Morrison as co-sponsors, okay? On that motion, without any objections, and
Thank
so
you, Madam
ordered,
Speaker.
and you may continue with your discussion.
Thank you, Madam Speaker. I first want to talk about the bill, and I'm going to, I usually don't like to compare Guam to any jurisdiction on the bill, which is dubbed 2 strikes and you're out. But I am forced to use California, which is the highest populated municipality in the United States compared to Guam. But I will use it because although they are the highest in population and Guam is one of the lowest, the thing that we share is that our crimes are the same. And I'm going to use California because they've adopted the habitual offender law. And I want to use some examples. In the early 1990s, in the state of California, 2 particular cases of recidivisms launched a growing need for enhanced penalties for habitual offenders. In 1992, an 18-year-old female was murdered during an attempt of purse snatching by a patrolled felon whose criminal history included auto theft, gun, and drug charges. He attempted, Madam Speaker, to just take her purse, and she resisted. And he pulled out a .357 Magnum handgun and shot her at point-blank range, ending her life. Her father went to the California legislature in support of adopting habitual offender laws. Now we know it as 3 strikes and you're out sentencing. Just a few months after he did that, we all may know a 12-year-old girl by the name of Polly Kloss, who was kidnapped out of her own home at a slumber party, and she was murdered. Her friends were tied up and gagged. That following year, 3 strikes and you're out was passed, Madam Speaker. in California. There is seemingly an increasing number of violent crimes occurring right here on our own island. Brutal assaults, rapes, domestic violences. Way too many violent crimes against women and children committed by career criminals who have no respect for the law or law-abiding citizens, nor do they feel the consequences. As one prominent defense lawyer put, they don't even believe they're going to get caught. On Guam, someone shoots his girlfriend over burnt rice. Another female was part of a home invasion where she was bludgeoned and still fights for her life, while the cohorts robbed her. Several young girls were raped for over a year, or I should say over 10 years, and it started when they were 8 years old. Another impregnated at 11. What do they all have in common? All these crimes were committed by criminals who have been incarcerated for crimes, and they somehow found their way back on the streets to reoffend and not rehabilitate. What do we tell the victims? What do we tell the families? One who is paralyzed for life, another has been hanging on for dear life. Children with the deepest wounds that will probably never, ever have the same life they did prior to these heinous acts, and will never heal as an individual. Do we tell them because of overcrowded prisons we're not able to help you? Madam Speaker, I believe that this legislature, from their actions in the past couple of months, has identified these problems. We've had recent bills that identify family violence, home invasion, and protecting your house while you're in it. The language in this bill is not to tie the hands of the judges, which has been the pushback that I've received from defense lawyers. I ask, how did the victim feel when her hands or his hands are tied? They are beaten to near death. In the case of the rapist at the bakery, his crime was his 14th on record. We can only imagine how many he got away with. This is a career criminal, a rapist, a man who likes to hurt women. This is a poster child for 2 strikes and you're out. The purpose of this bill, Madam Speaker, is to put violent criminals with a high rate of recidivisms. These individuals are not being rehabilitated, rather using our jails as a revolving door to reoffend. And when we reoffend, the current victim, the previous victim gets reoffended by the system. And we keep reoffending. A prominent lawyer said at the public hearing his clients can't get jobs. Well, what about the victim who can't go to work anymore because she or he is scared or depressed? We keep forgetting about the victims, and they will always be victims. The 2 strikes bill, Madam Speaker, should it become law, isn't a cure. I myself, as a humanitarian, would much rather see rehabilitated prisoners so that they can re-enter society and be productive members of the society that we all live in, our families, as law-abiding citizens. Ideally, our concentration should be on crime prevention through education. These career offenders didn't wake up one day and decide to start offending. They probably lack education foundation. A quality education is the best thing that we can do for our children to give them the best chance to succeed in life and not a life of crime. Whenever there's a mandatory sentence, there's immediate concern of overcrowding prisons, and it's a valid one. Guam's prisons is already overcrowding. But the problem isn't right now with convicted prisoners. The problem with overcrowding is pre-trial detainees. Madam Speaker, I know we're going to get respectful and responsible debate on Bill 107. So I ask this body to support this bill in an effort to protect the people of this island. Thank you, Madam Speaker.
On the motion, Senator San Nicolas, then I have Senator Yamashita, then Morrison. Is there anybody else? Senator Rodriguez, Senator Respicio. Okay, Senator San Nicolas, you're recognized.
Thank you, Madam Speaker. Madam Speaker, I rise in full and firm support of this legislation, and I want to do so with a clear message to all those people who would dare to commit these kind of crimes over and over again in our community. Crimes against children, crimes against women, crimes against people who are made victims for the rest of their lives. And the message is this, Madam Speaker. This is not a partisan issue. Democrats and Republicans are going to come after you, and they're going to make sure that you stop what you're doing if it means locking you up for the rest of your life. Period. I'd like to commend the author for taking the time to put this legislation together and for being brave enough to put this item forward. I know that there's been a lot of pushback on some areas with regards to the need for flexibility, particularly in the area of judicial discretion. And I can totally understand and respect that. We do have excellent judges, very, very prudent people who always look out for our community. But when we introduce legislation like this, it's because our community is expecting us to set a standard. And that standard is the framework within which discretion and judicial prudence is to be exercised. The role of the court is to interpret the law. The role of the legislature is to establish it. And we establish laws based on what the community wants. And the community outcry has not been that laws are too lax and criminals are being mistreated. It's actually the opposite extreme. The community outcry is that people don't feel safe. They feel like criminals are not cognizant, or even they don't care at all about what the laws are and how it affects them. They don't feel like the consequences are stiff enough to have them put their behavior in check. And we need to respond to that community concern, Madam Speaker. So I rise in full support of this bill. I think that the particular crimes that it cites are very, very appropriate. The original drafting of the bill did have a whole lot of other crimes that the author wisely vetted out with working with the Attorney General and other members of the body. But when you look at these crimes here, Madam Speaker, you look at this and you say, you never ever want to even imagine that these things are happening on this island. Much less imagine that the people who do these crimes are walking around on this island. I don't even want to even think about that. So I'm okay with a two-strikes bill. I'm okay with locking these people up. I'm okay with being able to rest easy knowing that our beautiful island is free of monsters walking around with the potential to ruin the lives of the innocent and good people who are relying on us to use our meat cleaver and cut a clear line down the middle between safety for our people and consideration for the offender. And that line is very, very clear of this bill, Madam Speaker. These crimes are not going to be tolerated in this community. Thank you, Madam Speaker.
Welcome, Senator. Senator Yamashita, you recognize.
Thank you very much, Madam Speaker, for giving me an opportunity to speak on Bill number 107-32. I want to start by saying that I have great respect for the author of this measure, and I know that he will listen to the comments that I have, and he will understand that I simply am raising them to ensure that we are looking at the whole picture. He ended his presentation by saying that this is an effort to protect our people. And I agree that the amount of crime that's happening on our island is atrocious. The types of crime that's happening across our community is unacceptable. We have absolutely unraveled to a place that shall not be. And so measures like this, all sorts of measures are now being introduced to give a clear message to those who dare hurt us, hurt the people we care for, the people we work with, or hurt strangers we don't know of. The clear message is you shall be punished. And that's the right message. You shall be punished. What I want us to also consider in listening to the public hearing and listening to all the focus groups, Madam Speaker, you and I have had several community conversations with victims. We are involved with the Attorney General in the Lanny Cade Act. We are developing or organizing No More Violence conference. And as we spend a lot of time listening to the victims, we know that Guam has a lot of work to do. So perhaps clearer, louder penalties is a part of that answer. But I have to also go on record as saying there's lots of other parts that also have to be addressed. And that starts with family education, with parenting skills. A lot of our victims are not born, a lot of our offenders are not born as criminals. A lot of our offenders are born and turn into criminals because of a lack of high-quality parenting, because of a lack of the kind of modeling that is needed. And so repeatedly, our abuse rates of our children has escalated. We have over 4,000 to 5,000 now a year of our kids being beaten up, being told to shut up. The last 16 months, we buried a 2-year-old who was buried with less weight than she was born with, Madam Speaker, a 2-year-old. While her siblings walked around her as she lived in a drawer. And yes, the parents were put into jail, and then they were released and they're having another child. Well, how about that? I posed questions like, what are we doing to help our criminal justice system? What are we doing to ensure the public defenders have the kinds of resources they need? We have listened to the Attorney General's office a few times talking about their need for victim advocacy, how they have 8 right now for the amount of victims we have, And we know of some crimes that have fallen through the cracks because they're just stretched. We must make sure that we help the Victim Advocacy Program. The Guam Police Department. Madam Speaker, even this session we're talking about how do we get them more police cars? How do we get them a place to come together? Or how about the 911 system? Those are all components of victims and offenders. And everybody, yes, I agree, we must talk about the victims. And we must make sure that doesn't happen anymore. But I have to also say, Madam Speaker, that until we understand the offenders, until we get a real good idea of their profile, it's not going to stop. What are we doing on our island, Madam Speaker, that is creating so much crime? Ridiculous, unforgivable crime. That when we were growing up, we never heard of it. But today, we hear of it every day. We all pray before we open the newspaper or look at the websites. And we always know who they are. We always know somebody who knows the families. And we all offer up prayers. And so, this measure is a message: you will be punished. But what happens, Madam Speaker, when a person is put away? Since 1989, across the nation, we have overturned 250 felonies, people who have served in prisons across the nation because the DNA proved that they were innocent. And collectively, this group of people served over 3,000 years in prison. I don't know if it's in this measure where we say, because it's clear that once you, whether it's 2 strikes or 3 strikes, I understand amendment might be coming, whether it's 1, 2, or 3 strikes, or I'm sorry, whether it's 2 strikes or 3 strikes, you're going to go away, you're not going to be eligible for suspension of sentence, probation, or parole or release. That's a clear message. Don't do it. And don't do it again and again, right? But what if the forensic science says, we messed up? What if there is a false confession? Somebody says, you know, I really didn't mean to say that. I got confused. I thought he was she and she was he. What if the appeals process was messed up? And then that whole DNA part. Madam Speaker, what I am asking is how do we ensure, as we stand for the victim, as we stand for them to ensure they heal and feel safe, and as we put those aspects into life for us on Guam, how do we ensure that those aspects are a safety net in case we did make a mistake? Maybe it's not in this bill, maybe it's somewhere else, I don't know. Maybe this is a rhetorical question, I'm not sure. But I ask that the whole picture needs to be addressed. Mover of this amendment names some people, some folks that we've known have names, and there's a Calvin Washington, a Willie Jackson, a Ray, a Frank Lee Smith, a Earl Washington. These are all names of people who died after their convictions were overturned, all felonies. But then the DNA was studied. And they died for crimes they did not commit, rape and murder. But somebody said, you did it, but they didn't do it. I support the strong message of 3 strikes, you're out. But I ask us to make sure that we strengthen all the other components that ensures that justice is fair. That we start when a child is born and we continue as that child grows. And when that child trips and makes a mistake, that he or she is taught and he or she learns from that mistake. That for those of us with disabilities, that we make sure the justice system understands. very hard to be on the other side, Madam Speaker. It's very difficult to be the parent standing there and saying, he didn't mean to do that, even though he did do it. Even though he did do it. And this legislature has enacted great policies. In the short time that I've been here, there's great support for having everyone understand the world of disabilities. But we sure have a long way to go. I'm not excusing our behavior. But I am saying, Madam Speaker, that we must strengthen all components so that justice is just. Madam Speaker, I look forward to hearing further deliberation on this measure. And again, I'm greatly respectful of the mover of this bill. Thank you.
You're welcome, Senator Yamashita. On the motion, Senator Morrison.
Thank you, Madam Speaker. It's very unfortunate that these violent crimes are taking place or occurring, elevating on our beautiful island. I know many of you, my colleagues, have been around this island for much longer than I have been, but I sure didn't grow up in Guam as we see it today. We never had to lock our doors, leave the windows open. And I believe almost every family or household out there has to lock the doors and secure their windows at night. Today it's clear, people don't feel safe. Madam Speaker, the public is concerned. There's an outrage in our community. They said it's enough. They took it to the streets. We joined them. Stand against violence. It's unfortunate that the author was criticized for introducing this type of legislation to do something about it. Obviously, maybe from those who probably never sat in a victim seat. Yesterday, my colleague introduced legislation on home invasion, making it a serious crime. He was prompted to do something about that. As we know, we've been seeing escalating crimes within our homes. There's jurisdictions out there that make home invasion a capital crime. It's absolute zero tolerance. I trust our judicial system, Madam Speaker, but we are a separate body that the people entrust as well, and to make laws to protect them, and of course give the judges discretion to uphold. If this legislation passed, I believe our judges will look within the spirit, Madam Speaker, and intent of this law when sentencing any individual at the character, background, or prospects, and have that discretion to place that individual outside of the two-strike zone or two strikes law. And it's clear, Madam Speaker, and the list is here. These are serious and violent crimes. So, Madam Speaker, it is obvious what this legislation does. Its spirit is clear, its intent is clear, and it defines with no question what violent crimes we would tolerate in our community. So, Madam Speaker, we must as a body stand against violence in our community, and this legislation does that. I commend the author for his hard work in putting this legislation together, and I stand against violence in full support of this legislation. Thank you, Madam Speaker.
You're welcome, Senator. On the motion, Senator Rodriguez.
Hafaday, thank you very much, Madam Speaker. Madam Speaker, I rise in full support of Bill 107-32, and I also like to congratulate and commend the author for moving this type of legislation forward. Madam Speaker, when you really take into account the discussions that are being had here today, and also prior to this measure being entertained on the floor, you know, at least for myself, Madam Speaker, I looked at it as in two ways. You know, I looked at it as a parent. I looked at it as a husband. And when you look at the crimes that are listed in this legislation, and you look at them: aggravated murder, murder and manslaughter, aggravated assault, kidnapping, criminal sexual conduct, compelling prostitution, and the list goes on, Madam Speaker. When you look at it as a father and as a husband, you say to yourself, you shouldn't take the second offense, surely not the third offense, to ensure that that offender is put away. However, Madam Speaker, as a policymaker, you need to look at the bigger picture, as one of our colleagues had discussed earlier. And there's a lot of factors that you must take a look at. However, when you look at really what the intent of this legislation is trying to do, Madam Speaker, it's not hard to agree and to support this type of legislation. When you look at the specialness of our island, the way we care for our families, the way we take care of our own people, and you look at these type of crimes that are happening, and it's happening by offenders that have been into prison for one reason or the other, have gone out either through a problem with the case in court, or some reason where they just find a way out, even after serving a long period of time in prison. Something is missing. We're not doing something. There's no rehabilitation. There's no effective rehabilitation that's happening. And yes, we need to ensure that we look at that component and see what needs to be done. But we can't wait, Madam Speaker. We need to ensure that we continue to protect our community, protect our children, our daughters, our sons, and our wives from these type of crimes. And so I rise in full support, and I ask our colleagues to join me in supporting this legislation. Thank you very much, Madam Speaker.
You're welcome, Senator. On the motion, Senator Respicio.
Thank you very much, Madam Speaker. Madam Speaker, I also rise in support of this bill, and I do it with some reservation, but certainly I commend the author for bringing this issue forward, particularly for letting us have this opportunity to really address what's going on in our island and how Guam today is not like the Guam I remembered growing up, Madam Speaker. And what's happening in our society today speaks to what has to happen with our justice system, not only with the incarceration aspect of it, but the rehabilitation, and also taking into account some other things that has to happen with how we dispose of justice, not only for the victims and their families, but how justice responds to those habitual offenders. There's the idea of restorative justice, which I continue to hope and pray never ever leaves our minds and our thinking, that the justice system, particularly the judiciary, continue to do things such as therapeutic jurisprudence, where they dispose of justice in a very non-traditional manner, where they have drug court for youth and adults, and also they have other type of alternative programs. But with Bill 107, Madam Speaker, I rise to support it particularly because of an opportunity I see in forcing this government to really address the shortcomings in our entire justice system and the lack of funding for the Department of Corrections, and how those officers have to go above and beyond, have to work beyond their regular work schedule, how they're continue to be owed overtime, Madam Speaker. And a lot of these problems really stem from an even greater problem that's been imposed upon our community via the compact impact situation. And we've had the Vice Speaker and yourself and other members of this legislature really ask the federal government, why is it okay that we have all these incarcerated FAS citizens and they're not moving to deport them back to their homeland, which costs the taxpayers of Guam about $8 million a year? Why is that okay that the United States enter into an agreement that allows for those migrants to freely associate to any U.S. or state or territory and have it impact the health, education, and public safety, but yet the reimbursements are lacking? And so if you recall, Madam Speaker, even through the Association of Pacific Island Legislatures, where we introduced a resolution that asked every single member entity to join Guam, CNMI, and Hawaii to put pressure on the United States government to honor the tenets of the Compact Impact, particularly the provision that requires for the deportation of those citizens who are in violation of the Compact. And you know, Madam Speaker, that under the terms of the Compact of Free Associations, citizens of the freely associated states, which includes the sovereign states of the FSM, the Republic of the Marshall Islands, and the Republic of Palau, have entered into the United States, may enter the U.S. under a special status and are treated as foreign nationals while in the United States, and such status is allowing the U.S. to deport a citizen of any COFA state if such citizen is found guilty of breaking or disregarding the laws of a U.S. jurisdiction. A COFA citizen shall be considered deportable if convicted of a felony or a crime of moral turpitude, or if sentenced to 1 year or more for any crimes committed, or if the COFA citizen becomes a repeat offender for driving under the influence. And such COFA citizen in violation of the COFA will be treated as any foreign national and shall be deported if convicted of a deportable crime under the terms of the Compact of Free Association. And so we see how many COFA citizens have had habitual and repeat offenders for driving under the influence, are sentenced for a crime of a year or more, or even for crimes of moral turpitude. And yet, how no matter how many times we've asked the Attorney General to notice the United States immigration of these deportable offenses and let immigration be the ones to move forward toward deporting them. Madam Speaker, a couple of weeks ago, I had lunch with the FBI through the FBI Citizens Academy, and then they brought up how under the Compact Impact, those islands are required to submit these names of those offenders from their jurisdiction to a federal agency such as the FBI, and so they can maintain a database, and so that when these individuals want to migrate to Guam or any other U.S. jurisdiction, immigration has the authority to prevent them from entering our borders, and they're not doing that. And so I'm seeing an opportunity in Bill 107 because we recognize that if you do 2 strikes, 3 strikes, and you're there for life, we have to recognize what that's going to do to our current population up at the Department of Corrections. And so if we don't move to deport these FAS citizens who are deportable, then we're just going to continue to exacerbate the problem. There's even some discussions that we had with the United States Senate staffers and Congresswoman Bordallo to have them build a federal prison in Micronesia. And so if we start to have our Attorney General notice the United States immigration of what these individuals are doing and how they've been convicted of these deportable offenses, then we can continue to push the issue of how to address the problem on an even larger scale. And so I'm offering an amendment to Bill 107-32. Copies have been made and been disseminated, and I've already addressed sections 1 and 2 of this amendment. And this amendment on item 3 says, upon conviction of a deportable crime, the Attorney General of Guam shall immediately notify the U.S. Immigration and
Senator, we
Customs.
don't have a copy of it.
Joe, oh. So I believe it's being passed out right now. And as they're passing it out, Madam Speaker, the third item of this amendment says, upon conviction of a deportable crime, the Attorney General of Guam shall immediately notify the U.S. Immigration and Customs Enforcement Division of the U.S. Department of Homeland Security of Guam's desire to have the COFA citizen deported. The AG shall work closely with the U.S. ICE Division of DHS to ensure all documents related to the conviction and required for deportation are immediately provided to the proper authorities. Citizens of the U.S. cannot be deported under the terms of the COFA, and the AG shall transmit a quarterly report to Legislatura indicating how many cases were forwarded to U.S. ICE Division of DHS for deportation and the status of those cases. The AG shall also publish this report on its website on a quarterly basis. And so what this amendment does to this bill would say that if any COFA resident is convicted of any deportable offense, it simply requires that the AG notify the U.S. Immigration of these individuals and the crimes to which they've been convicted, and then let immigration be the one to move forward and honor the tenets of the compact impact. And so, Madam Speaker, I offer that as an amendment at this time.
On the amendment, Vice Speaker.
Madam Speaker, I don't oppose the amendment, and I support the intent of the amendment. I just want the body to be aware of the fact that for the last 4 years, I've been trying to work with the U.S. Attorney's Office on this very issue. And I hate to be the one to say it, but ICE has a better census of who the prisoners are up at the Department of Corrections than our own Department of Corrections. They are up there on a daily basis. And when I've met with them and I've met with the U.S. Attorney, they could give me the number, the name, the number, the offense, the number of years that they're in, and every stat that was necessary. They have it. They've had it, H-A-D-D-D, for years. And they've done nothing. Yeah, this is another one of those, the tail trying to wag the federal dog. And I'm not opposed to it. I fully support the idea. I just wish I knew how to make that dog bite its tail and move on. It is really frustrating trying to deal with them because they will tell you and they'll show you their list. You know, I was out there and they start the list off, and between DOC and the ICE person, the number is 400 or some number, and the ICE says it's a different number, and then they go through the list and find out that ICE has the better list. They have it. I just have not figured out how to make them go about doing it, and I'm not sure whether or not local statute is going to do any more than what they already are mandated under a compact which under the Constitution of the United States is supreme law of the land. It's a treaty. The Compact of Free Association is approved by the Senate. It's a treaty of the United States, supreme to the laws. They've ignored it. They've ignored it as it relates to the reimbursements, and they're ignoring it as far as these are concerned. We passed a resolution yesterday trying to deal with one part of it. I fully support the intent of this. I'm just expressing my frustration at trying to figure out how you make the federal government do what it says it's supposed to do under its own laws. Thank you.
On the Respicio amendment, Senator McCready.
Thank you, Madam Speaker. When I found out about this amendment, I thank the author and the mover of this amendment. And as you can see on the piece of paper, I also co-sponsored it with him. And I thank him for his forward thinking, because this completes the bill. And I believe it makes it stronger. As I read yesterday when we were discussing the Compact Impact Treaty, it states that in '86, Compact of Free Association between the Federated States of Micronesia and the Republic of Marshall Islands, and later Palau, and the United States of America, created this immigration law for habitual residents. And we're finally identifying through this amendment, or I shouldn't say finally, but we are identifying through this amendment, because it also states here that it's for educational and employment that this treaty exists, that what happens when they come here and they're not productive members of society, and they do commit crimes, and they do fill the jails with 2, 3, or 4 DUIs, and they do put some of our people in danger. So, Madam Speaker, I raise in full support of this amendment. And I thank the author, or the mover of this amendment. Thank you very much.
On the Respicio amendment, Senator Limitiaco, you're recognized.
Thank you, Madam Speaker. I rise in support of the amendment that was offered by our good senator from Agani Heights. And I do so just to build upon a resolution that we sent to the third reading file yesterday, because as previous speakers had alluded to, we really do need to figure out how to stop the bleeding, stop the draining from our general fund that is being imposed and placing a burden on our community as it relates to supporting the Compact of Free Association. And I believe that this amendment accomplishes 2 things. One, it definitely frees up our Department of Corrections of having to house these criminals that are convicted, and it deports them back to their country of origin. And this basically is what we heard in the public hearing on the main subject of Bill 107. And what was expressed was that you need to look at the system in a holistic fashion, that just making it a 2-strike law and just saying if you violate for these violent crimes after 2 times, you're going to be put in prison for life. You can't just do that without addressing the system in a holistic fashion. And this amendment goes to solve one of those problems. That's the overcrowding of our Department of Corrections. And that's exactly what we heard at the public hearing, and it's definitely part of the solution and the overarching holistic approach to solving this problem. I rise in full support of this amendment, and I ask my colleagues to do so as well. Thank you, Madam Speaker.
You're welcome, Senator. On the Respicio amendment, Senator Nicholas.
Thank you, Madam Speaker. I rise in full support of this amendment, and I kind of just wanted to go on the record and talk about just how much I support this amendment. You know, the question keeps coming up of how are we going to get this thing to actually be enforced? And we already have numbers on how much per day it costs to house a prisoner in our prison system. And I was just chatting with our Vice Speaker about I'm even willing to include an amendment to the amendment that would tag that daily rate onto the utility bill of the immigration office so that they can either pay for the daily rate, deport them, or get their lights turned off. I mean, I bring this up, Madam Speaker, not in jest, but as a symbolic gesture of how serious I am, and I believe other members of this body are, about the need for the federal government to finally start meeting us halfway with regards to its obligations, particularly when it comes to the Compact of Free Association. And I'm so troubled by this, Mr. Speaker, because our neighbors in the neighboring islands are good people. And historically, we have had a great history. But now it's coming up to the point where our own people on this island are starting to have conflict. And the opinions of our neighbors are starting to be conflicting, and it's very, very sad. It has to end. But the only way that that's going to end is if the Compact of Free Association is actually fulfilled to the fullest by the federal government, who's supposed to be coming through on their end with regards to the impact on our community. And there are ways, and I wanted to stand up and speak about this, Mr. Speaker, because there are ways for this local government to begin tagging these costs to federal operations here on the island. Do we need to go down that road? Do we need to take those necessary steps? We're not doing it out of a lack of ability. We're not doing it because we don't know any better. We're not doing it because we're not creative and we're not clever. We're not doing it because we value our relationship with the federal government. We want to be co-equal partners. We want to treat each other with respect. But for years and years and years, we've been standing in the corner with our hat in our hand, saying, we're doing our part, can you please help us and do yours? We're doing our part, can you please help us and do yours? And I just want it to be very, very clear that the good nature of our people is not something to be taken for granted. That there are leaders in this body and on this island who do recognize the generations and generations and generations of good-natured intentions of our people, awaiting graciously the fulfillment of the federal government with regards to its obligations to our people. But we are also ready to start taking those necessary steps to figure out how we're going to get in and around and start receiving what it is we're supposed to. And I ask the federal government not require us to go down that road. So I rise in support of this amendment. I'm not going to proffer my amendment to the amendment to tag the daily cost of the housing the prisoners to the power bill of the immigration office. Not because I don't know any better, but because, again, even I am going to stand here with my hat in my hand, proverbially, and say, we are awaiting you doing your part in this relationship. Thank you, Madam Speaker.
You're welcome, Senator. On the Respicio amendment, Senator Uggan, you're recognized.
Thank you very much, Madam Speaker. I'll just make this fairly brief. You know, we ask ourselves in terms of what are the implications of this particular amendment. And it's to comply with an agreement or to ensure compliance of an agreement in which the people of Guam, the leadership of Guam at that point in time, had very little input into. And that's exactly what this amendment would do, Madam Speaker. It would require that any individual from these particular jurisdictions who commit a major foul, and it says is found guilty of breaking or disregarding the laws of the U.S. jurisdiction, that they be possibly deported back to their hometown. But let me add just also an added perspective, Madam Speaker, because some people might step forward and question, what about their loved ones who are here? What about the young ones who may have to return home? And to that particular inquiry or concern, I say, Madam Speaker, that individual who committed that crime should have thought about that before that incident occurred. Because guess what? Any criminal act, regardless as to who commits it, regardless as to where they originate from or where they reside, has implications. And that is implications on yourself, implications on your family, implications on your household, because in some cases, household extends beyond the immediate family, and implications on the community. And that's where this amendment would ensure, or at least try to find a way to further enforce that any individual found guilty of breaking or disregarding the laws of the U.S. jurisdiction, in this case, as it applies to Guam, shall or may be deported as a result of their criminal act. And I encourage our colleagues to support this. Obviously, there's a tremendous amount of support, but we look at it also from the financial implications. I think we should divulge ourselves away from any financial cost and look at what the impact is on our community. Because our job here is to ensure public safety. Our job here is to pass laws that would ensure that the people of Guam, anyone who calls Guam home, whether it's for a lifetime or on a short-term basis, Madam Speaker, that we can ensure to the greatest extent possible the safety of all of the citizens who are residing here. So I stand in full support of this particular amendment. Thank you very much, Madam Speaker.
On the Respicio amendment, Senator Munia Barnes, you recognize.
Madam Speaker. Madam Speaker, I want to share some of the same sentiments that the previous speakers have spoke about in supporting this measure. And I just want to note for the record that in our efforts working with the Council General of the FSM that's stationed here in our island, who was the former governor of YAP, and also working closely with the president of FSM, I want to share with you that in our presentations and working together and collaborating our efforts so that the residents of FSM, Balao, and RMI are inclusive in making and working closely with our communities as it relates to just being able to be a part of the community. They have shared with me that if anyone who's come from their hometown and who's violated the privilege that was and the blessings that they were given to be here, and they are not going to be regarded or take advantage of what we have to offer, then they should go back. They should go back home. And Madam Speaker, when I look at this resolution and I see the many years of us working with our island brothers and sisters to collaborate as one community and working to better the lives and opportunities of our island people, I want to say that even the Council General today, with their colleagues, have stated that if someone does not respect or does not uphold the laws that are governed here, and that they want to disregard or disrespect that, then they have no business here. So Madam Speaker, as I looked at this resolution as proffered by Senator Respicio and
It's an amendment, not a resolution.
I mean, the amendment. I want to say that this is only right. I'm sorry, it's Senator Brant McCready's bill, but the amendment by Senator Respicio. I just want to say that this should be done. So I rise in support of the amendment, of the amendment.
Is there anybody else who would like to speak on the Respicio amendment? Okay, there being none, Senator Respicio.
Thank you very much, Madam Speaker. Madam Speaker, I'm certainly grateful for all the comments made by our colleagues, particularly the co-sponsor of this amendment, Senator McCready, that agreed that this could be an opportunity to put this language into his Bill 107-32. And I also want to say what I said in the beginning when I recognize the efforts of the Vice Speaker over the years, particularly how he was able to quantify that the impact of the COFA residents to the Department of Corrections alone for those that are in a deportable position is about $8 million a year to the general fund. And so, Madam Speaker, this amendment does not mandate the U.S. Immigration and Customs Enforcement to do anything. It simply mandates the Attorney General of Guam to report those deportable individuals who are involved in this deportable type category to USI so they can move forward. I can tell you for the record that the issue here and the reason why we need this amendment is we have to mandate the Attorney General to do this. I think if he sees this, then certainly he won't have a choice other than the situation now where I think philosophically he just doesn't want to move to deport any of these individuals. And this is why I think this amendment is very, very important. And so I appreciate all the comments of our colleagues, and I appreciate the opportunity to place this amendment into Bill 107-32. Thank you, Madam Speaker.
So on the, since I've not heard, no one has registered any opposition for the amendment, I'm going to then just make sure one more time that there being no objections to the amendment. So ordered. On the main motion, I have next to speak will be the Vice Speaker and Senator Lim Tiaco.
Thank you very much, Madam Speaker, for recognizing me to speak on the main motion. I rise with mixed emotions about this bill. And I do so because it's not that I don't understand and support the intent. I mean, all of us have been victimized with thefts, but that's not the thing that this thing really is addressing. I mean, I fully understand the reaction of the families. Only 2 of you were alive when I was 5 years old and I lost my father to a murder. 6 of you weren't even born when I was victimized for D. So I fully understand and I want to do something about this. But I am not sure that a 3-page bill is going to handle this, even with the amendment that they thought was going to make this whole complete. I appreciate the fact that the main sponsor took into consideration the early criticisms about the list of crimes that were initially listed in the bill as originally proposed, and took out a whole bunch of the crimes. But I'm really, really, really disappointed that we completely ignored the testimony that was given at the hearing by the two members of the Public Defender's Office. And I'm not talking about the judicial discretion. The court can take care of itself. I'm concerned about the two other groups that the two public defenders talked about that needed some kind of way to be addressed in this bill. We don't have to go back very far in history, Madam Speaker, to know about some of the reactions that some of our very well-educated, well-placed members of our community who come back from the horrors of the wars in Iraq and Afghanistan and are set off by something in the protection of their child. That would be strike one under this. We have 600 of them coming back. We keep talking about the fact that we have 15,000 or 16 or 18,000. And one of our colleagues made mention at the hearing about the fact that at 7 o'clock in the morning, I still wasn't up, I was getting a call, frantic, crying. She was crying. What do we do about this one person who the helicopter's flying over his home, set him off, and he was out there with a gun? That would have been strike one, if not strike three. Those of you that have your iPads, go on to the blotter for today. There's an incident of a gentleman, and I won't even mention his name, who I knew from when I was handling family court 20 years ago. Threatening people with a hatchet that fortunately he didn't have. But we have another one on today's paper where it's between a son and a mother on the assault. The public defenders made two very compelling arguments for us to address. How do we take care of those members of our community who have mental illness? Because so many of the crimes that are committed by individuals who are mentally ill, but may not be so mentally ill that they can actually satisfy the not guilty by reason of insanity, but are having a meltdown. How do we address them? There's nothing in this 3-page bill that says those of you that go through the mental health court that we funded for $100,000 last year to address are going to be exempt from this. We have the gentleman that a couple of years ago, I was in the legislature at the time, and most of you were, who was shot to death at the Veterans Cemetery because he was grieving the loss of his brother. And they shot him because he had a cigarette lighter that looked like a gun. The good Congresswoman is considering legislation to try to find some money for a veterans court. because we're finding throughout the country that the men and women that we sent off to fight these, mind, I won't put an adjective on it, I'll just say these wars, are coming back with traumatic brain injury and post-traumatic stress disorders. We have many from our own generation, Madam Speaker, who we see walking up and down the street that are doing things that we know don't look like they're all together. But I don't know how we would be, even as sane as we think we are, if we were to be in a situation where we were in Vietnam, like my roommate was in sophomore year when he came back, and he was screaming in the room, and I couldn't figure out what was going on, to come to find out that he was at the My Lai massacre. And saw the hundreds and hundreds of people that the men in his division killed. We'd snap. As strong as I think I know I would be gone. When I was handling family court, I was asked, my doctor told me I had to step down because it was affecting my health, because I was taking personally the fact that some of my children were committing suicide on me. And it was unprofessional of me to be taking it so personally. Imagine witnessing hundreds of people dead, or seeing your best friend in 1,000 pieces, and coming back and trying to deal with whatever happens around the house, with something going off and you just snapping. There were nights that it took all four of us in the suite to hold him down when he was flailing around with his malaria attacks and just dreaming. But there's nothing in here to address those 15,000 men and women who, because of the freedoms that we want, we sent off and damaged. And we don't put enough money in at mental health to address it. And with all we've had, I don't know how many roundtables on the veterans trying to figure out how we're going to help them get their assistance. And so, because we don't provide for them in here, God help them. If the helicopter's flying overhead, cause them to freak out. Or when one of our friends, our family members, who we know are suffering from mental illnesses, who for some reason that none of us can figure out, something sets them off. A date that may be the anniversary of something, a smell, a loud noise, and they go off and they beat up some member of the family. That's B. This is a very well-intentioned bill, Madam Speaker, and it's not that I'm opposed to the idea of making sure that people who commit offenses are duly sentenced. The longest sentence I imposed while I was on the bench was a double life plus 15. So in the event that he came back after he died, he would have another life term, and if he came back as a vampire again in a third life, he'd have 15 more. So it's not that I'm opposed to long sentences. It's we've got to realize what we need to do. And when I was at the court, I used to fight with parents because I was going to send their child off to some special school in the States. And I was taking $80,000 a month or $100,000 a year of taxpayer money to send them off to a specialized school because I refused to wake up one morning and find out that this child had killed every member of his family. And the parents were screaming at me. I said, let me tell you, I would much rather take this $100,000 and give 2 scholarships to Harvard. I assure you I would love to do that. But I'm sitting here in this family court and I have to make a decision. Do I leave this child in your house with you, knowing how dangerous he or she is? And the possibility that I'll wake up tomorrow morning and find out that he's killed all of you? I'm sorry. But the community can scream at me for spending that kind of money. But some of them with the mental illnesses that they suffered needed to have that kind of specialized attention. We had a hearing last year in this next room where a mother was talking about her 10-year-old child who was sent away because he was sexually assaulting people. 10. He'd be away for God knows how long of this. Madam Speaker, more time needs to be taken on this bill. More things have to be added besides the COFA amendment, which I support. And I'm willing to overlook the fact that we've completely ignored the whole argument about judicial discretion. But I really think that as policymakers, we must address the 2 things that the public defenders brought to our attention. How do you deal with the mentally ill who are not insane but are having mental stresses and breakdowns? And how do we deal with a group of 15,000 men and women that we've sent off to fight our wars for us, and we don't provide for them when they come back, and they snap for some reason? Until we address those 2 components, Madam Speaker, this bill's premature. Thank you.
You're welcome, Mr. Vice Speaker. On the main motion, Senator Lim Tiaco, you're recognized.
Madam Speaker, I'd like to kindly request for a short recess.
Okay, take a recess. Senator Lemchako, you have the floor.
Thank you, Madam Speaker. Madam Speaker, I rise in full support of this measure, and I commend the author for being brave enough to move forward, knowing full well that it would be scrutinized as it should be. The public hearing that was held, as all bills are required to go through, brought out opponents and proponents of the bill. We heard the stories of the victims who supported the bill. We heard from the Attorney General's office, who also supported the bill. And we heard from those in the legal field who pointed out potential unintended consequences of nonviolent offenders potentially being sentenced to life for lapses in judgment or the potential of a mental health illness. And as the retiring speaker had pointed out, it would be a disservice if this body did not take into consideration the testimony of these legal professionals at the public hearing. And as he pointed out clearly, that there were two specific issues that they brought to light, one being the mental illness, as well as our inability as a government to provide for proper or addressing education and early childhood development, as well as assisting in our education systems to provide for the addressing of the mental illness. And I took it to heart as well. I really do respect the former speaker's judgment and opinions, and I know he has a wealth of experience in this field. You know, we've heard from the community who echoed a consistent concern that the whole system needs to be addressed, not just changing the laws to put people away after 2 convictions. The whole system needs to be addressed, and I think this body recognizes that. It was brought out in the public hearing. It was thoroughly reviewed on our radio stations as well as in our media. And I know that this body took those comments just as if they were part of the public hearing, and they incorporated it into what is this revised bill. But we still need to address our police department, our Department of Corrections, our judicial system, and our Guam Behavioral Health and Science Department. You know, as a first step, the author and the co-sponsors have taken into consideration what was heard in the public hearing, and the author removed several lesser crimes and only focused on the violent crimes, and specifically crimes against our children. And just recently, during the session, the good senator from Agana Heights proffered an amendment regarding the COFA that would address the overcrowding at our Department of Corrections. And in regards to the judicial purview and discretion, I do have an amendment to proffer to the bill that would not only give our judges more discretion, but also take into consideration everything that was heard at the public hearing, to try and strike a compromise between what this bill attempts to achieve by getting tougher on crime, but also taking into consideration, and of course, not only being tougher on crime, but also for respect and consideration of the victims of crime. And Madam Speaker, my family was part of that at one point in time, and unfortunately, that criminal still walks the streets. So like the prior speaker, it's near and dear to my heart. It still pains me to talk about it. As much as I want it to be 2 strikes, I recognize all that was said in the public hearing, and we really do need to take that into consideration. So, Madam Speaker, I'd like to proffer 2 amendments. In light of the fact of what we heard at the public hearing, and in recognition of the fact that we have yet to address the system in a holistic fashion, from our police department to our Department of Corrections, until we address those, I'd like to ask, or excuse me, proffer the following amendment to section 2B, or excuse me, 2A, in which the following language will be changed. On page 2, line item, or excuse me, line 4, the word felony shall be changed to the plural felonies. And on line 5, the word A shall be changed to 2. And Madam Speaker, what this amendment will basically do is change this bill from a 2 strikes law to a 3 strikes law. And this accomplishes a couple of things. One, it gives this body more time to address the system holistically, in the sense that we really do need to figure out how to properly fund our police department, our Department of Corrections. And I believe that the COFA amendment by Senator, the good senator from Magana Heights is done. It also addresses the issue of judicial purview and discretion. And I believe that it's basically saying to our judicial system, we have 2 chances to get it right before this law applies. And then we need to act responsibly and put these criminals away for life. And I'm hoping that in that time period, that this body figures out ways to address the system from start to end so that we can address the issues that were brought up in the public hearing. So, Madam Speaker, as a technical amendment, Section B, 1, line 11, if we can have the legislative clerks also correct where felony needs to be changed to felonies, or where the words conviction needs to be changed to convictions as it applies to the changes in the amendment.
On the amendment on page 2, starting with line 4, felony, singular to plural, felonies. Line 5, the deletion of A, the letter A, to 2, and a general technical correction to change from singular to plural. On the amendment, no objections? So ordered. Yeah, well, the clerk and legal counsel would make sure that where appropriate, yes, for technical correction. You still have the floor.
Thank you, Madam Speaker. Madam Speaker, I have a second amendment, which I think builds upon the retiring speaker comments and his extensive knowledge of what this bill could have an unintended consequence of, and that's how it affects our servicemen that are coming back, or any person with a mental health condition that may not be at their full capacity when they're committing these crimes that are listed in this bill, Madam Speaker. And for that, I would like to offer a provision adding a new section D, which states the following: if the court certifies that the defendant has a mental health illness, then provisions of Section A do not apply. And once again, this goes back to allowing our judges and our judicial system the judicial purview and discretion that they need in order to determine on a case-by-case basis how this applies to each of these defendants, and to exercise their judgment and experience to arrive at the proper sentence.
Can you repeat that again, please? And it's going to be in page 2, a new B.
It will be in, Madam Speaker, it'll be, I believe, in page 3.
3.
Yes, Madam Speaker. It'll be on page 3. It'll be a new section, or not new section, but it'll be a new item D to section 2. Oh, that's correct, Madam Speaker. The COFA amendment was D, so it would be a new item E which will read, if the court certifies that the defendant has a mental health illness, then provisions of Section A do not apply.
On the amendment, Senator Uggan, you recognize.
Thank you very much, Madam Speaker. I'd like to thank the proffer of the amendment and also for the previous speaker for recognizing situations where, in fact, it may involve veterans. I stand in full support of the amendment, and obviously, when it applies to veterans as well as those who have a mental illness, just for the information of the community, there are ongoing efforts not only from Congresswoman Berdalia's office, but also from the Judiciary of Guam, and likewise from the committee that I have oversight over in terms of looking at the eventual creation of a veterans court. And I think once that proposal is presented before this body for consideration, you're going to recognize that there are certain factors that come into play, and certainly mental illness is part of that particular component as it applies to any of our veterans that have to receive treatment and have to go through the judicial system. So, Madam Speaker, in the meantime, I think this amendment would address some of the concerns that have been shared a little earlier with us in regards to individuals who perhaps may act out, or individuals who do act out as a result of a mental illness rather than out of an intent to impose harm on any individuals that fall into any of these categories. So I certainly stand in full support of the amendment. Thank you very much, Madam Speaker.
You're welcome, Senator. On the Lim Chaco amendment, Senator San Nicolas, you recognize.
Thank you, Madam Speaker. I too rise in support of the amendment. However, I do have a question for the good senator offering the amendment.
Senator, you want to ask your question first?
Yes, I do. And my question is, I understand that the intention is to allow for the courts to certify that if the defendant has a mental illness, then in so doing, the Section A won't apply. But I wanted to find out, do you think that we need to tighten the language a little bit more so that the courts have to look at it and confirm that the mental illness was a contributing factor in the commission of the crime versus just having a mental illness in general? Because somebody could, for example, have anxiety and then go out and commit premeditated murder, and the defendant can show that he's been seeing a specialist, and so the courts will see that and see that they've been seeing a specialist, but the courts also would know that there was no commission, that mental illness was not a contributing factor in the commission of the crime. And so, but because of this provision in the law, would we then be opening the door for unrelated illnesses to be allowances for the exemption? So I wanted to proffer that as a question. Maybe we should tighten it up.
Thank you, Madam. Thank you, Madam Speaker.
Yield?
I do yield to the question, and I thank the good senator from Dedido for bringing it up. And I think if we look at this new amendment, and if we look at it in the context of the bill as a whole, and we go to the Section 1 of the legislative findings, I believe that the intent of the bill in of itself would guide the applicability of this mental illness provision, in the sense that what we're trying to achieve here is that recognizing the crimes of these habitual offenders and the courts determining whether or not this mental illness is in fact a contributing factor to the habitual pattern of these criminals. So I think if we take the amendment on its own, yes, I believe the good senator from Dedido has a valid point, but when we look at the bill as a whole and we look at the legislative intent and the spirit of the law, I believe that the amendment is consistent with the intent of the bill. However, I'm open to amendments. I just want to reiterate that this amendment is being proffered in light of the good senator, the previous speaker had pointed out that we're failing to address in this bill those that have been afflicted, whether on their own how they live their lives, or potentially from any sort of service that they have been engaged to, or any type of traumatic stress that they've been exposed to, and to recognize that we can't just be tough on crime without realizing the contributing factors and the fact that the mental health of the individual as a contributing factor, as defined and expressed in as a habitual offender portion of the legislative findings in the bill, that we really do have to be more prudent in addressing that and take that into consideration and give our judges the discretion and the purview to determine, based on their case-by-case basis, taking the entire case into consideration, whether or not, in fact, this mental health illness is a contributing factor to the crime and potentially the habitual crimes of the defendant.
So, Senator Nicholas, were you? Okay, so on the Lumpiaco amendment, Senator Talmada, you recognize?
Thank you, Madam Speaker. I'm still somewhat confused about this because I remember clearly from the public hearing, one of the defense attorneys that testified indicated that many of these people that get brought in to court have mental health problems, are mentally ill, but not to the extent that it'll get them off the hook. Now, I guess, we can take a look at the amendment that's being proffered as maybe a more subtle way of giving the judge that judicial discretion to be able to say, okay, well, then this 3 strikes doesn't apply because he's got some mental illness. And I'm just concerned that are we now redefining the legal definition of mental illness? And so I'm quite frankly, I'm not quite convinced that we've gone far enough to really address the concerns that have been raised earlier and during the public hearing. And so, if we're if the amendment is in fact then that subtle way of giving the judge that discretion by saying, oh, he's got mental illness. Well, and so what if, is being Edgo a mental illness? And, are we now defining that as a mental illness? I don't know. And so I'm still struggling with this whole issue here. Thank you, Madam Speaker.
On the Lumpiaco amendment, is there anybody else who would like to participate in the discussion? Senator Lumpiaco.
Thank you, Madam Speaker. And just to address the retiring speaker, this amendment is not attempting to define mental health illness at all. It's leaving it up to the court and the judges to have the discretion to define it, as they currently do now. And I'm sure that what they do is they probably bring in experts to help them, mental health experts, to help them determine whether or not they fall under this category. So no, what we're not doing is trying to redefine anything. What we're saying is, as they do in the court system now, we're going to leave it up to the court to determine. And what we're saying is that in the event that the court certifies and determines that it is, in fact, a mental health illness as a contributing factor, that they have that purview to determine the applicability. So, Madam Speaker, in closing, may I close now?
On your amendment, or?
No, I'm done with the amendment.
Okay, so you're done with the amendment then. So, okay. Before maybe we move on, there's a question that has to be answered here. If you can please all look on page 2, line 9. where your B is, it says both of the following must occur, but underneath there's only a 1 and there's not a 2. Senator Limpiaco? I know, I thought he said he was done. Are you? Yes. Well, yes, well, we did on the, well, we don't, the clerk doesn't have a copy. Can you please make sure? Yeah, you wrote it down then? Okay, so on that amendment, which will be a new section, and the clerks and legal counsel then would appropriately name the sections that, and I don't have the whole wording, but if the court certifies that, I guess there's a mental illness, that section A, I would not apply. In general, that's what you're trying to say. Is that correct? Okay. A new subsection E, section E. No, because D is COPA. On that amendment, no objections? So ordered. Okay, Senator, so that's, do you have other amendments?
Yes, Madam Speaker, thank you. Just as you were about to point out in Section 2B, it refers to, in order for this penalty under this section to apply, both of the following must occur. And of course, as you were alluding to, that it only stipulates one item. I would just like to ask if the author would yield to a question as to what the second condition of Section B is.
Senator McCready, do you yield to the question? Is there a number 2?
Madam Speaker, if I could request a short recess so that we can identify.
We're going to take a brief recess. Senator Limpiaco, you're recognized.
Thank you, Madam Speaker. If I could proffer the following amendment to address Section 2B, line 9. We're going to be striking out the comma as well as the following words, both and of.
Okay, on
So
the
it's-
amendment on page 2.
So it should read, in order
Line
for this
9.
penalty under this section to apply, the following must occur.
Yes. On the amendment, no objections? So ordered. Is there any other amendments?
Madam Speaker, no further amendments.
Is there anybody else who would like to speak on the main motion? Speak Speaker Pangilinan, you're recognized.
Thank you very much, Madam Speaker. Madam Speaker, it's certainly commendable in terms of what we're trying to achieve in this bill, which is to create a safer community. And in that respect, there really can be no good reason to oppose the intent of the bill. As we all know, sometimes when we try to provide a simplified solution to a complex problem, we may miss the mark, or we may find ourselves having to deal with being much more broader than we want to be, and not taking into considerations all of the elements involved with what occurs in the commission of a crime. And I think that we find ourselves, I know over the years here that we've had to come back and change things when we find that. But is that a reason not to do anything? Certainly not. Can we protect our community with our existing laws? Yes, we can. And it's going to take a concerted effort to protect our community even with this bill in place. There are many studies, and we can look at both from theory and academic studies of why men, women, people behave the way they do and what influences those behaviors. And then there are many studies that are evidence-based, which takes a look at what occurred, discounting for any kind of influences that may have prompted that individual to act the way he did, and just say he acted this way, period. And when we do look at those studies, we know and we find that in most instances, the solutions offered to prevent those kind of individuals, those kind of criminal acts, do not lie in any kind of greater sentence or greater incarceration. And that those are just what we have been able to see over the years as we all look at what has occurred in communities across the country, across the world, and certainly within our own community. So in that respect, Madam Speaker, I just wanted to voice those opinions and kind of take a look at where this would take us, what the effects would be, what the ultimate results would be, and would we be, in fact, ensuring a safer community. And we may ensure ourselves a safer community from, 50% of the population that perpetrates crime upon victims. And are we then at a greater point in terms of community safety with that? So, Madam Speaker, I just wanted to kind of voice those thoughts so that we can all continue to take a look at and think about the solution being offered and the problem it hopes to solve. Thank you.
Welcome, Mr. Speaker. Senator Uggan, you're recognized.
Thank you very much, Madam Speaker. Madam Speaker, with the amendments that have been incorporated into this measure, and I've been very upfront with the sponsor of the measure in regards to my position. I stand here now in full support of this particular provision. Madam Speaker, when we were having the public hearing on this measure, it made it extremely difficult for me to sit there and to listen to the real life perspective of a couple of the victims who provided testimony. Also, in addition to that, I was personally visited by an individual who had shared their perspective. And I say their so that I don't share the agenda. But, Madam Speaker, it's really very difficult when, in fact, you listen to the victim and then you try to balance in terms of how can we make this a safer community. There have been statements made about lacking the provision necessary to provide the AG's office with the resources so that they can carry out their responsibility. There's been comments made about not providing GPD with the additional resources and some of our law enforcement entities. And you know, Madam Speaker, being in this body, obviously, I'm trying to balance the overall presentation and prioritizing different areas because we certainly have areas of public safety, healthcare, and education that we all collectively share our priorities of this government. It's how those resources are allocated. And we look at this legislation and we say, okay, community of Guam, there's one message that is being imparted, is that this legislative body, through this legislation and other legislative measures that have been introduced by our colleagues in this legislature, as well as in previous legislatures, is that we collectively as a community are going to will be tougher on criminals. Will be tougher on criminals. But then there's one provision here that recognizes unique circumstances. Whether we want to refer to it as mental illness or other perspectives which will be forthcoming in veteran legislation. But Madam Speaker, we look at this and the underlying concept is whether it's 2 strikes or one notch higher, 3 strikes. This community will not tolerate any major felonies or criminal acts where in fact it's going to be continuous on the part of an individual. And what would be the repercussions? Department of Corrections may have to provide additional accommodations, and that's going to be a challenge again on this body and also a challenge to our community. Not in terms of how to accommodate that, but to how to ensure the proper compliance and enforcement of this particular provision. There was a particular statistic that was shared with me that individuals who have committed a felony, that 50%, the first felony, that 50% of those individuals return to commit their act. And my response to that individual who shared that information was yes, but there's also that 50% who had rehabilitated, returned back to the community, and in most cases, I would presume, because they didn't return to their criminal act, had become perhaps responsible members of our community after the first incident. And I think that what this provision does now in its present amended form, it recognizes that. It was tough for me with the looking at it from the perspective of the initial provision when it was introduced, only because of the challenges that have been highlighted by several members of this body about providing the system with the resources so that we can take care of these particular situations and minimize any criminal activity towards our community and towards individuals. In a perfect world, Madam Speaker, the Attorney General's office will probably get an additional $7 or $8 million so that they can hire additional attorneys, hire additional advocates, hire additional personnel. The judicial system would get the additional $5 million that they're requesting so that they can carry out their respective operations. GPD would get funding necessary to provide additional police vehicles as well as additional police officers out in the streets, uniformed police officers. On and on and on. But we face challenges. And realistically, obviously, we have to live within our means. This provision will send a resounding message, Madam Speaker, to members of this community that if in fact you commit a major criminal act that, sorry, Madam Speaker, I think a major thought just crossed my mind in regards to if in fact it was committed towards any of my children. But if you commit, sends a message to individuals in the community, you commit a major criminal act that falls into this category, yes, you may be sentenced. Yes, you're going to have to pay retribution back to this community. But you will also be given the opportunity to rehabilitate. And hopefully that's a route that they would take. And if you commit two and convicted of a third, then your life is going to be spent in incarceration for the rest of your life in terms of either Department of Corrections, whether it's a correctional facility or a detention facility. And Madam Speaker, with this message, I hope one of two things. One, that it will work to put away the hardened criminals who are repeat offenders to this community and to our people. And I also hope that it serves a second intent, and that is it serves as a deterrent for anyone to move in this direction where, in fact, they have to be put away for life. Thank you very much, Madam Speaker, and I stand in full support of this measure.
On the main motion, is there anybody else who would like to speak? Then I would call the primary author, Senator McCready, to close.
Thank you, Madam Speaker, and I would like to thank, and I'm very proud to be a part of the 32nd Guam Legislature. I'd like to thank former Speaker, Vice Speaker, who I have the utmost respect for in this body, and including yourself, Madam Speaker, for the respectful and responsible debate and allowing this bill to be heard on the floor today. And I thank my colleagues who stood in support, and I also thank my colleagues who had some reservations. I thank my colleagues who added some strong amendments. And at the end of the day, it reminds me of the public hearing that we had where the victims asked us not to fight for their protection, rather to come to a amicable solution. And I think that was shown here today. So I thank you very much. I'd like to add one final amendment. And I'd like to add Senator Yamashita and Senator Uggan as co-sponsors of the bill. Thank you.
On that amendment, no objections, so ordered. On the motion then to send 107-32 LS to the third reading file, no objections, so ordered. We have a set aside, which is 100. Senator Munya Barnes. Okay, 97, Senator Rodriguez. Well,
Thank you, Madam Speaker. Madam Speaker, I move to place Bill 97 as amended by the author and the Committee on Appropriations, Public Debt, Legal Affairs, Retirement, Public Parks, Recreation, Historic Preservation, and Land for the third reading, and be allowed to briefly discuss it.
Yes, you may proceed, Senator.
Thank you very much, Madam Speaker. Madam Speaker, first off, I'd like to add Senator Ben Pangilinan as the second co-sponsor.
On that amendment without any objections,
Third
so
sponsor.
ordered.
Thank you. We caught that. I'm joking. Thank you, Madam Speaker. Madam Speaker, what this bill does is that it identified about $3.4 million from the Guam Territorial Highway Fund that was highlighted in an audit report by the Office of Public Accountability. And this fund, Madam Speaker, is available cash that is open for reprogramming and appropriation. And we've identified several projects throughout the island that have been on the radar of Public Works for a very long time now, and each and every one of these items here are something that Parks and Rec has taken a look at, and one way or the other has been able to assess and put a cost estimate, although some may be preliminary cost estimates, but have been vetted through the department. And so we're identifying these projects specifically. Also, one of these items here, Madam Speaker, which is item number 2, which page 3 of the bill, it identifies about $2 million, a little bit over $2 million for the Director of DPW to work hand in hand with the village mayors to be able to do some flood mitigation work. The mayors, during the public hearing of this legislation, said they wanted to be able to provide a list of 5 priority projects in their village for DPW to be able to see how, with the funds available, do the work that needs to be done in those villages. And so we've gave the Director of Public Health the flexibility to determine which projects could proceed with the funds available to them. Yes, the Director of Public Works. Is that what I said? Oh, I'm sorry, Director of Public Works. And so, Madam Speaker, I ask my colleagues to please support me in this legislation. We've verified that the funds are indeed available, and this is something that is ready to go. Thank you very much, Madam Speaker.
You're welcome. On the motion, Senator Munya Barnes, you're recognized.
I promise, Madam Speaker, real fast. I just want to thank the Speaker, the author of the legislation, for giving me the opportunity to be a part of the co-sponsorship. And after working closely with the mayors and trying to identify the most pressing road projects that need to be fixed right away in their villages, we've come up with this version, and I'm hoping that our colleagues support the same. So thank you for giving me this opportunity to rise and support Santa Mas.
You're welcome. On the motion, Senator Agun, you're recognized.
Thank you very much, Madam Speaker. I too would like to stand in support of the legislation, but you know what's interesting is obviously the good senator, the sponsor of the legislation, had gone through and sought assistance and input from the Department of Administration to identify some of these resources and ensure that the funds are in the account. And you know, if any of our colleagues would like to yield to come to the assistance of the Chair of Judiciary in terms of helping to identify the remaining balance of what their request is for the merit bonuses, it's more than welcome, Madam Speaker, because I've tried to communicate with DOA on separate occasions to identify funds. So I just wanted to mention that, but in all seriousness, on the proposal, I think that whenever we have funds available that could otherwise be utilized to be given back for good investment purposes such as this, to help assist the mayors, to improve the infrastructure, to improve some of our roadways, to improve specific projects or facilities, I think it's always, in the end, going to be that much more beneficial to our island, to our community, and to our mayor. So I stand in full support of the legislation. Thank you very much, Madam Speaker.
You're welcome, Senator. On the motion, are there any other, anyone else like to participate? Senator Rodriguez, send it down. On the motion to send 97-32, the third reading file, without any objection, so ordered. Well, we have, these are the ones that we have that has not set aside as 100. 108 set aside. 118, Senator Rodriguez. 132, Senator Rodriguez. And 120, Resolution 127. Those are the ones that we have on the list. We have, again, 100 set aside, 108 set aside, 118, 132, 118 by Senator Rodriguez on the responsible alcoholic sales. 132 by Senator Rodriguez on the revolving loan funds. 127, a resolution by Speaker Pangilinan. I'm going to take a brief recess. Recognize Senator Rodriguez on Bill number 118.
Thank you, Madam Speaker. Madam Speaker, I move to place Bill 118-32 as substituted by the Committee on Aviation, Ground Transportation, Regulatory Concerns, and Future Generations on the third reading. Be allowed to briefly discuss the bill.
Yes, Senator, you may proceed.
Thank you, Madam Speaker. Bill 18 is one of those rare pieces of legislation, Madam Speaker, that offers a single solution to several issues. Broadly, these issues are the licensing disparity that exists between workers who serve and sell alcoholic beverages on our island, a recent change in the law that includes jail time for providing drinks to minors, making it easier for ABC to conduct more effective enforcement and compliance of alcohol laws, and reducing the amount of alcohol-related crime and social problems our island experiences, especially underage drinking, public intoxication, and DUI. How Bill 118 does this is simple and straightforward, Madam Speaker. First, it requires an ABC license for all workers who serve and sell alcoholic beverages on our island. To get that license, these point-of-sale employees will have to complete a short training course that focuses on the responsibilities as servers and sellers of alcoholic beverages and understanding the consequences they face for not living up to those responsibilities. Second, it will relieve ABC of certain administrative responsibilities and place it in the hands of organizations that have proven capabilities in licensure, education, and training, freeing ABC employees to spend more time on enforcement and compliance issues. Just to be clear, Madam Speaker, the bill as it's written now identifies these organizations as nonprofits as well as government entities. It will equip servers. Third, it will equip servers and sellers of alcoholic beverages with skills that can help them be a more effective partner in the fight against underage drinking, public intoxication, and DUI. Point-of-sale employees, whether at a bar, restaurant, supermarket, mom-and-pop store, gas station, or other retailer, are the first line of defense against underage drinking, DUI, and public intoxication, problems that eat up precious resources of police, prosecutors, and the courts. What happens at the point of sale is perhaps the most crucial link in a more effective community-wide partnership to make Guam safer and more enjoyable for all who live and visit here. Until now, point-of-sale workers have been mostly overlooked in this effort. They certainly have not gotten the support they deserve from the rest of the community to help them do a better job. Server-seller training addresses this oversight. There are other benefits too, particularly for servers and sellers. These include making licenses good for 3 years instead of having to renew annually. It also makes licenses portable. Currently, an employee has to apply and pay for a different license for each job they hold. With passage, there will now be a single alcoholic employee license fee, and the cost of training will come out of that fee. It is clear that Guam has many alcohol-related problems. Hardly a day goes by when alcohol-related crimes are not in the news. Many of these problems and the cost dealing with them can be avoided if we attack the problem proactively at the point of sale rather than waiting for them to occur and then acting. Server-seller training does this and much more. But just as importantly, server-seller training also builds confidence that the men and women our island has entrusted to dispense alcohol, whether by the glass or by the six-pack, to fully understand and comply with the responsibilities of their licensed occupation. Frankly, Madam Speaker, right now that confidence is lacking. So I ask my colleagues, Madam Speaker, I thank the 8 of my colleagues who are co-sponsors of this legislation for joining me, and I ask the rest of our colleagues, Madam Speaker, for their positive consideration. Thank you very much.
Welcome, Senator. On the motion? Bearing none, so on the motion then to send 118-32 to the third reading file without any objections. So ordered. Resolution number 127, Speaker Pangilinan, you recognize.
Thank you very much, Madam Speaker. Madam Speaker, I would like to move that Resolution 127-32 as substituted by the Committee on Appropriations, Public Debt, Legal Affairs, Retirement, Public Parks, Recreation, Historic Preservation, and Land be placed in the third reading file.
And would you like to speak on it?
Yes, Madam Speaker.
Okay, you may proceed.
Madam Speaker, Resolution 127 is a resolution seeking to express the sentiments of the Guam legislature with regards to supporting bills that have been introduced in Congress to expand the Radiation Exposure Compensation Act of 1990 to include the areas of New Mexico, Idaho, Arizona, Colorado, Nevada, Utah, Missouri, and Guam, and to improve and increase compensation for those affected by ionizing radiation. Madam Speaker, currently in the House, Senator Ben Ray Lujan of New Mexico has introduced a bill to add these areas to what we call the downwinders category that would make then residents of these areas during certain time frames in which there were tests of the atomic programs, of course in the area of New Mexico, Idaho, Arizona, Colorado, Nevada, Utah, Missouri, those tests were conducted within the Nevada desert area. And for Guam, the tests were conducted in the Marshall Islands. And the evidence to support our inclusion in this was gathered, documented, and compiled, and a report was written under the direction of Mr. Robert Celestial and the Blue Ribbon Panel that uncovered declassified documents which showed that Guam received significant radiation fallout from the Marshall's nuclear tests. And upon presentation of that evidence to the National Academy of Sciences, the National Academy of Sciences Brer Committee recommended that Guam be included in the downwinders category. And so while we in the past have tried to pursue a bill for Guam only, we find that we have gathered allies through the work and the networking of the PARS organization, Pacific Area Radiation Survivors Group, in networking with the other grassroots organizations in those states that I've mentioned, have been able to secure the support and the introduction of legislation in the Senate as well with Senator Tom Udall of New Mexico to make these areas and to include Guam in their bill that would allow us to qualify under the downwinders category. In addition to including and opening up compensation to residents of these areas, the bill would increase the compensation and make it uniform with other Americans who have suffered from ionizing radiations in the atomic program, such as uranium miners and transporters. And so the bill basically extends our support and lends our support to the efforts of these congresswomen and congressmen and senators in their efforts to get this program implemented that would provide compensation to the residents of Guam and the residents of their states. And what is very important, Madam Speaker, is that the way that the program is written is such that if you suffer from any form of cancer that has been listed in cancer that has been accepted as being due to exposure to radiation, you don't have to prove a link to your exposure. You just have to prove that you are in the area, number one, and do you have these types of cancer, and then you would automatically qualify. So it also simplifies very the application process and the qualification process. In addition, areas that are affected by downwind ionizing radiation exposure would also qualify for certain health benefit programs under the RECA program. That would allow us for testing, it allows us for education and outreach, it may even allow us for a medical clinic to be established in Guam, or give us access to medical clinics to get a certification of the cancer that one suffers as part of the application process. So, Madam Speaker, this again is a continuing effort. This is not the first time we're doing this. This is not the first time that Congress will be entertaining a bill to increase qualifications and eligibility under the program. But as they continue their efforts, we shall also continue our efforts to help support these allies of Guam who have introduced this legislation in the Congress and are seeking to bring us along with them and their residents for inclusion in the downwinders category of the RECA program. So I ask my colleagues to assist me in this effort and ask for the favorable consideration in passing this resolution. Thank you, and Sidus Masi, Madam Speaker.
On the motion, on resolution then 127-32 LS to be sent to the third reading file without any objections, so ordered. We will recess until tomorrow morning at 9.